Hello, my name is Craig Altman, and I am the founder and president of Tradition Software and Tradition Lien Service. We are both national companies that serve the U.S. construction industry and help you navigate and successfully use each state's respective construction lien laws, along with doing public works projects, claims, and also federal claims. Today, I'm going to talk to you about construction lien law in the state of Georgia. Going back into college, I did military duty in the Army at Fort Gordon, Georgia for a few months back in 1987, which is going to really date me or give me experience. I've also enjoyed immensely dining in the Buckhead district at Houston's and then going north about an hour to Chateau Elan Winery for dinner one night. So you have a beautiful state, and I'd like to help you about construction lien law. But before I do that, I have to give you my standard legal disclaimer, and that Tradition Software, Tradition Lien Service, and myself makes no warrant, express, or implied for the use of this video, our websites, our software, pre-lien to lien, or the documents prepared by Tradition Lien Service. In no event shall Tradition Software, Tradition Lien Service, or myself be liable to anyone for any problem, claim, or loss arising out of the use of our videos, websites, software, or document preparation services. Tradition Software, Tradition Lien Service, and myself are not engaged in practicing law in the state of Georgia, nor does Tradition Software, Tradition Lien Service, or myself provide legal advice in the state of Georgia. Okay, let's talk a little bit about Georgia construction lien law. Initially here, as I share my screen, I am going to show you that on traditionsoftware.com, we have a drop-down menu off of the homepage where if you go to state deadlines, you can go down alphabetically to Georgia. And we're going to have a nice one-page cheat sheet about lien law as it relates to the state of Georgia. We're going to talk about first notice being required, an optional lien warning notice, and a construction lien in those timeframes for that, if you get to the point you need to make a claim. Also on traditionlienservice.com, we have the same type of situation where you can go to a drop-down menu off the homepage, go to state deadlines, and select Georgia here in terms of the issues related to construction lien law for Georgia. Now, initially here in Georgia, if you are a subcontractor, there is a notice that needs to be done at the beginning of a project for both commercial, existing residential, and new residential projects called a notice to contractor. And I'm going to be real honest with you. Our experience over 17 years is that many people in Georgia, many contractors and suppliers in Georgia are not using this notice as much as the law says they should be using it. And if you're not doing it, you're more lucky than good. But we definitely recommend, per the law, that a notice to contractor go out. And it's something that subcontractors should send within 30 days, the first day of providing delivery of materials or beginning labor at a project. It should go by certified mail to the owner and be sent also to the prime or general contractor on the project. Okay. And, you know, with that, you want to make sure that whoever you think is the owner on a project is the actual owner. And so we do provide a service here called a property owner report that is included if you are a Tradition Lien Service customer. It is an option that you can purchase on a bulk basis if you use our pre-lien to lien product for Tradition Software. And basically think of your typical Circle K or your Publix supermarket that might be somewhere in Georgia. You are not going to always have Publix or Circle K corporate be the owner of the property. And this is a property owner report actually for Circle K that was built in Cordell, Georgia. And my apologies if I'm mispronouncing that city wrong. And it wasn't Circle K that owned it, but was actually somebody else who was leasing the space to Circle K. So it definitely is something you need to keep in mind as it relates to verifying who the property owner is if you're going to be doing a notice to contractor. And later on, especially, you've absolutely got to have correct the property owner and the legal address that they can be corresponded with. Okay, so Tradition Lien Service can do this document for you for $26 in 1 to 5 business days. With traditionsoftware.com, you can actually use our pre-lien to lien software product by leasing it on a year-by-year basis. And here you're going to enter the project information as it relates to your project in Georgia. In this particular situation, I'm showing a Texas project. And enter the information, click your print notices button, and you're going to get a Georgia state specific menu here to print your notices on. Shame on me for not having a Georgia project on the screen, but this is an option that you have by leasing our Tradition software pre-lien to lien product. Okay, going back to Georgia lien law, if you do not end up getting paid on a timely basis, you then need to think about doing a lien warning notice, which for the state of Georgia is totally a bluff, meaning that it is not required by state law. If you were to go to some other states like Kentucky or Tennessee or Nevada out west, it is a requirement that you do a notice of intent, or Colorado also too is a state that requires it. Georgia does not. But we definitely recommend that you think about doing it. I have an example here on the screen of the notice of intent that we would produce either out of our software or out of our Tradition Lien Service. And by the way, I didn't show earlier the notice to contractor document. Again, if you just recall, I had talked about the fact that people rarely use this, but look at this is noted in state code here, that you should send out this notice here. So anyway, the notice of intent is going to have about a 25 to 33% success rate of shaking the trees and getting the owner or the general contractor, if you're a sub, to pay you. It generally has a 10-day warning attached to it. And you're going to want to send it by certified mail to the property owner, and it's highly advised you send it by certified mail also to the general contractor on the project if you're a sub. However, if you don't get paid after a warning notice, or if you're in a situation where you just want to cut to the chase and do a actual construction lien in Georgia, especially if you're a general contractor and you don't have to do the first notice for Georgia, or you have done the recommended first notice, or you haven't done the first notice and you just want to take your chances with doing a lien and see how it holds up in court if you get to that point. The recording of a claim of lien needs to be done specifically within 90 days after last providing equipment, labor, materials, or services on a project. And there is no differentiation in Georgia between the timelines for commercial projects, existing residential projects, or new residential projects. And I do have an example here of a claim of lien here that was recorded with the clerk of Superior Court. And this particular one was done in a county near Atlanta. And forgive me, I'm all of a sudden spacing here on the county here because it was recorded with the clerk of courts. But excuse me, County of Fannin. Forgive me, I'm not real smooth here this afternoon here. It was recorded with Fannin County. But you're going to record it with the clerk of courts for Fannin County, and actually there it is right there. And the fee amount is generally going to be $25. We e-record across the state of Georgia, so that's something that we can do here for Tradition Lien Service. Otherwise, you've got to go to the clerk of the Superior Court in the county where the project is located in order to record your lien. Okay. And once your lien is recorded, you then have the lien basically good for 365 days. Okay. Now, that is going to cloud the title for 365 days. It's going to prevent somebody from selling the property for 365 days. But you do need to think about hiring an attorney to do what's called a foreclosure lawsuit, or a fancy word for it is a Liz Pendens lawsuit on the lien. An attorney is going to be probably $5,000 or so, but if you're owed a significant amount of money, if you're not paid right away on the recording of a lien, then you do need to think about hiring an attorney. And that's something that we can't help you with, but there's a lot of good construction attorneys in the state of Georgia that can help you. Okay. Now, if you do get paid on your lien, you need to release the lien again. And it's not just a standard waiver at this point. You've actually got to record again a release of claim of lien. And again, like I have here with Fannin County, you're going to do it with the clerk of courts for the county. Again, you're going to be looking at a fee amount of $25. We can do it for you through e-recording through our traditional lien service division, or you can certainly attempt to do it yourself by using our pre-lien to lien software solution. So we would love to work with you at either Tradition Software through our pre-lien to lien software product, or at Tradition Lien Service. We are a national company that works with over 1,000 companies nationally. We've done a lot of work in Georgia. We can be reached Monday through Friday at our 800 number, which is 800-886-8770. We are Central Standard Time here in suburban Chicago. So, we are open from 8 a.m. to 5 p.m. Monday through Friday. And you'll more often than not speak with me. I'll give you a quick 5-minute opinion. As stated earlier, I'm not an attorney in the state of Georgia, but we're well qualified to help you. We've been in business for 17 years, and we've been helping companies all around the country. I thank you for your time, and we look forward to helping you if you give us a call. Have a good day.